will gain us fruitful knowledge, exchange of ideas in various aspects of law. And I'm also proud to welcome on the second day of conference our keynote speakers. Actually, we have 4 keynote speakers, but one of our keynote speaker, which is Dr. Ahmed Bastawi, is in health issue. So today we will have 3 keynote speakers from different expertise of law. And the first speaker is Dr. Iman Prihandono from Faculty of Law Universitas Airlangga Surabaya. The second speaker is Ms. Hana Saima, which is the project assistant to counter trafficking and labor migration at IOM, UN Migration. And the third speaker is Professor Maria Teresa Gilbaso from University of Navarra, Spain. And before we start our presentation for today, the notes is each speaker will have about 20 to 25 minutes for presentation. And after all the speaker present, the presentation will be followed with the question and answer session. And audience may ask directly by send question in the chat box by mentioning his or her name and also the institution. Now, please allow me to welcome the first speaker, Dr. Iman Prihandono.
Okay. Thank you very much, Ibu Patricia.
Yeah.
Audrey.
Before we start Dr. Iman Prihandono presentation, I will give a brief explanation. Dr. Iman Prihandono is a lecturer at the Faculty of Law Universitas Airlangga Surabaya, and he obtained his PhD in law from Macquarie University, Australia in 2013. Currently, Dr. Iman Prihandono is the Dean at the Faculty of Law Universitas Airlangga Surabaya. His research contributes to the field of international law with a focus on multinational corporation law, investor-state dispute settlement, access to remedy for victims of corporate abuses, transnational litigation, and business and human rights. His research has a particular focus on business and human rights issues in Indonesia, where he has conducted extensive legal research. And today, Dr. Iman Prihandono will deliver a topic presentation about human rights and international cooperation. Dr. Iman, the time is yours.
Yeah, thank you very much, Ibu Audrey, for the introduction. First of all, I would like to thank Faculty of Law, Universitas Brawijaya, and the committee of BILC for inviting me, for having me here today. I'm honored to be here among the honorable guests and other speakers. And I wish you all safe and health, particularly in this time of pandemic. Let me just share my presentation first. Okay, I hope it's already in your screen. Like Ibu Audrey mentioned before, my presentation will be on human rights and international cooperation. Previously, the title was Human Rights and Transnational Cooperation, but I was not sure whether transnational cooperation can be the right term that we use in our studies. Yeah. But that does not matter. I will first give a brief introduction why international cooperation is needed, and then I will relate these issues, international cooperation, with our current pandemic situation. Why international cooperation is more needed in this pandemic situation. Uh, it is important to recall that human rights in nature is universal, inalienable, indivisible, and interdependent and interrelated. However, at the same time, today we have seen the growing gaps between states, the growing inequality, increasing over time. For instance, children born in one country with the worst health condition is 60 times more likely to experience health bad health condition, uh, and also to lose life. Or children born in country with best access to education can expect 10 to 15 times less years of education compared to children born in country with worse access education. So these are our current world that we are living today. Yeah, it was a result. Actually, it is a result actually from unequal power of relationship between poor and rich countries, uh, and also uh, the reasons of liberalization and privatization in many different sectors that contributes to this situation. Um, Human rights, as we know, is universal. It implies equal entitlement to human rights by everyone. So it should be borderless, regardless of geographical location. Uh, Although we found the ICG, for instance, once decided in its advisory opinion on the legality of a wall in Palestinian territory, which impose primarily that ICCPR primarily territorial and jurisdictional obligation, but different scholars argues that civil and political rights is has an extraterritorial characteristics, and the example is huge, uh, a huge number of example that we can see. For instance, on migration issues, just because a person is in the status of migrant, it does not mean migrants means he or she have to flee from her or his own country. It does not mean that, and it does not mean civil and political rights of a person can be violated. Also, it is important to recall that states also have obligation under economic, social, and cultural rights, that is to cooperate to and to assist internationally. The same with UN Charter, which promote cooperation and universal respect for observance of human rights. There are a number of international cooperation that have been going on and growing today. It can be divided into two main types. First is cooperation by entities. States have been the number one entities who actively involved in international cooperation. North-South, for instance, South-South, triangular, and etc. Also, international organizations. We have seen many cooperation between international organizations, the World Bank, IMF, WTO. Uh, uh, it impose the members an obligation to cooperate each other. Yeah. Even though the works of some of these organizations perhaps can have positive and negative impact on the fulfillment of human rights. The role of non-government organizations, CSOs, civil society organizations, also important to spur cooperation. For instance, Oxfam, Greenpeace, Save the Children, WWF, in the area of environmental protection, forestry, and other issues. By works, there are different cooperation have been going on, but the majority is in the field of human rights and development and in the issues of human rights and democracy, because these two issues have been linked very closely with human rights issue, the development and democracy. We have declaration on the rights to development and General Assembly resolution, which acknowledge that development is an inalienable human rights and that the human person is both an active participant and beneficiary of the right to development. The same with democracy, human rights fulfillment have been very closely related to the level of democracy in a particular country. So working on human rights cannot be separated with development and improvement of democracy in one country. Universal Declaration of Human Rights, for instance, itself emphasize that the will of the people shall be the basis of the authority of government, also acknowledged through the right to assembly, freedom of expression, and other civil and political rights. So those are the reason why international cooperation on human rights is needed, and how international cooperation has been fostered by states, entities, or by works of other groups. Yeah. However, the development on international cooperation in human rights also face some challenge. Usually, international cooperation now is predominated by Western foreign aid in the field of development and democratization, but also the player of international cooperation have now been moving, shifting from more powerful countries to a more diverse countries. Yeah, for instance, rising powers like Brazil, China, and India have been working towards international cooperation more actively in the last 20 years. Or second-tier partners like Turkey, Indonesia, Malaysia, and Chile, and other smaller and more sporadic donors. For instance, Singapore have been actively working on international cooperation and providing donors to different countries. Despite those efforts, there are a number of challenges to human rights cooperation at international level. The Human Rights Commissioner the High Commissioner for Human Rights in 2019, for instance, notes that there are at least 5 challenges to human rights cooperation. The first is the increase of political movement against cooperation itself. Multilateralism has been shifting into unilateralism. Globalization itself, for instance, has caused states to work on its own interests rather than global interests. Several countries see increase of hate speech. Yeah, indeed, hate speech has been our problem today, both nationally or internationally, with the increased use of social media that can hinder international cooperation on human rights in several ways. Also, public rejection against international aid and migration or asylum. Of course, migration issues will be discussed further with our other presenter. Secondly, pushback on right previously won by women and minorities in several countries. Instead of growing protection on women and minorities, some countries have been moving backwards to protect women and minorities. Again, globalization and privatization might be the major cause. Thirdly, the increase of restriction on civic space by several countries, which goes against democratic ideals. So there is a tendency, an increase of authoritarian and oligarchic in several countries. So it is a decrease of democratization. We've seen decrease of democratization. These issues particularly have been obvious in several Southeast Asian countries. We have heard what happened in Thailand, in Bangkok today, with the increase of rallies and demands for the monarchy to be more, and the authoritarian military government to be more democratic. Also, the widening inequalities of income, wealth, access to resources, and access to justice. The fifth is some issues also inherent in the way international cooperation is framed. Yeah, we've seen the weakness, disadvantages of having veto rights, for instance, in UN Security Council mechanism, which hinder a fast and quick response from the UN to save life, perhaps, for instance, in Syria and in Myanmar. So the way international cooperation is framed today is actually has contributed to the challenge of human rights cooperation. I will now relate my presentation on human rights cooperation between states with our current situation in pandemic COVID-19 disease. Yeah. As we know, health is part of human rights. It is formulated as the highest attainable standard of physical and mental health. Yeah. It contains in the Universal Declaration of Human Rights, Economic, Social, and Cultural Covenant, and it requires progressive realization. Okay, different with civil and political, the economic, social, and cultural rights implies that the fulfillment of economic, social, and cultural is progressive realization. However, many scholars argues that in this time of pandemic, progressive realization is not proper. It's not enough for the government. Yeah, the obligation of state to protect should include taking immediate public health steps to spread the pandemic from growing larger, to stop more victims, yeah, casualties from the pandemic. And why international cooperation matters more in the pandemic than ever? These are some numbers that we can access. For instance, the COVID-19 pandemic has infected over 10 million people and killed more than 500,000. And the global GDP, Indonesia, for instance, the Ministry of Finance have declared that Indonesia is entering a time of recession because of the economic, because production, the reduce of demand, global demand, and the it caused slower production industries in producing goods and services. Trade in global merchandise, for instance, will be dropped by 18.5%. On the other hand, most of the labor force around the world in industrial, in manufacturing sectors. So yes, more people will be placed in the vulnerable position during this pandemic. The pandemic also has exposed fragilities and the failure of international system. Yeah, despite the industrial relation 4.0, or now some people said that we have entered into 5.0 industrial relation. Despite those advancement technology, artificial intelligence, and etc., this pandemic shows that the world is not actually ready to face a catastrophic like what we have faced today. So, for instance, the delay in global health responses, and also the global supply chains problems during the early period when pandemic was first hit. At the same time, it is often the only way for the most fragile state to access much needed resources in the pandemic. So, pandemic has left most fragile states, the developing and less developed country, are most fragile, for instance, because of political inefficiency, social issues, economic disparity, conflict, natural disasters, and many others. Uh, so we've seen now today a huge gap between responses and resources between country. That's why we need a better way to cooperate, particularly on health issues, because health is part of human rights. Uh, can the pandemic revive multilateralism? Uh, like I mentioned before, there is a tendency that the worlds have moved from multilateralism spirit into a more unilateralism. Okay, it might be the world can shift back to multilateralism. History suggests that three elements are necessary. First, there should be new ideas, because the current situation, the current form of international cooperation proved to be failed. New ideas is needed. Secondly, enlightened leaderships. Perhaps the current leaderships of the world might not be ideal. Thirdly, favorable global balance of power. Uh, what should be prioritized during the pandemic era in terms of international cooperation? First is vaccine development. Of course, we need share of virus strain, for instance. Some scholars argues that vaccine produced by AstraZeneca or produced by Chinese pharmacies will not be compatible with virus strain in Indonesia or in other country. Therefore, cooperation is very much needed. Medical supplies, apart from vaccine and medical supplies, cooperation on to tackle poverty, hungers, and access to healthcare remains important. On the pandemic perspective, we need to increase speed and transparency of international communication, collaborative effort to analyze emerging concern and policy issues, and development of evidence-based guidance and communication for international public. From a forward-looking perspective, this is my last presentation. We have to address inherent issues in today's international cooperation. Yeah, first we have to focus on empowering fragile countries instead of maintaining the status quo of reliance. So yes, there should be a balance of power between countries. Secondly, we have to create systems that reduce possibility of human rights and international aid being used as just another diplomatic arsenal. For instance, China is now trying to gain more influence in Southeast Asia because on the issues of which related on the issues of South China Sea. So this should be separated. And also, we need to create, we need to create better preparedness for future global issues. We are not ready for another pandemic, I'm sure. and also to improve current mechanism of international health cooperation to allow better identification, monitoring, and resolution of future pandemics. I think that's all my presentation, Ibu Audrey. We can continue with discussion later. Thank you very much. I will stop there.
Okay, thank you very much, Dr. Iman, for the wonderful presentation and very informative about human rights and international cooperation. So I think I will give a brief summary for all of us. Akan saya sampaikan dalam bahasa Indonesia. Jadi berdasarkan tadi apa yang dipresentasikan oleh Dr. Iman Prihandono adalah nilai utama dari hak asasi manusia adalah melekat kepada setiap pengemban haknya dan memiliki nilai universal. Tentu saja adalah kewajiban bagi setiap pemegang hak asasi manusia untuk memperjuangkan penghargaan terhadap nilai-nilai HAM tersebut. Dan salah satu wujud perjuangan ini dapat dilakukan dengan adanya kerjasama internasional. Khususnya kerjasama internasional ini perlu kita lakukan sekarang dalam masa menghadapi masa pandemi ini. Adalah hal yang penting. Antara lain beberapa hal yang dilakukan adalah peran negara dalam bagaimana dapat memanage, melakukan prioritas-prioritas dalam penanganan bencana COVID-19. Termasuk juga diikuti dengan langkah-langkah efektif melalui adanya pengembangan fasilitas, kemudian kerjasama penelitian dalam melakukan mekanisme nyata untuk pemenuhan kerjasama internasional ini. Nah, terima kasih. Kita sekarang we will move to our second speaker, which is Mrs. Hana Saima. Mrs. Hana Saima is Project Assistant to Counter Trafficking and Labor Migration at IOM UN Migration. Mrs. Hana is a human rights devotee. She graduates her master's degree in international law and security from the University of Glasgow. And she also a Bachelor of Law in International Law from Universitas Brawijaya with a cum laude mark. Her research interest is in the field of international law, especially in human rights, along with mostly advocacy experiences in human rights NGO, law firm, and research institution. Today, Ms. Hana Saima will deliver material about human rights and migration. Ms. Hana, the time is yours.
Thank you, Bu Audrey, for introducing me. I will. Okay, wait a minute. Okay. The slide is ready, yeah?
Okay.
Okay. So, good day, everyone. Thank you, Ms. Audrey, and all the committee of Brawijaya International Law Conference for inviting me to be one of the speaker in these occasions. Allow me to present a brief recap on human rights and migrations, and hopefully we can have a fruitful discussions in the end, because I would like to hear some perspective on the issue. So first of all, I would like to start with what is actually right to migrate on the international human rights perspective. Well, literally, there is not mentioned right to migrate inside the Universal Declarations of Human Rights. However, Article 13 of the Universal Declarations of Human Rights explain that everyone has the right to freedom of movement and residence within the border of each state. as well as they have the right to leave any country, including his own, and to return to his country. Oh, sorry. Okay, my bad. Okay. Okay, we're here.
Is there any problem, Miss Ayu Hana?
Yes, it's because I'm using the two screen. So it needs a bit adjustment. I'm sorry for the inconvenience, but I think we're here. Okay. Is it show now?
Yes. Okay.
Okay.
Yes, yes.
Okay, so arguably, the Universal Declarations of Human Rights does not provide a right to move into any other country. However, if we may take a look at Article 2 of the UDHR and the reason why UDHR existed and adopted by the General Assembly is because the international community proclaimed the acknowledgement of human rights is of all human beings and fought never to allow another atrocities to happen again. And by doing so, the state committed to protect human rights of every person in the territory, including migrants. The elevations of a limited freedom of movement to a human rights has been also affirmed in numerous of international conventions. 28 years after the General Assembly adopted the UDHR, ICCPR reaffirmed the freedom of movement, stating everyone lawfully within the territory of a state shall, within that territory, have the right to liberty of movement and freedom to choose his residence. Unlike the UDHR, the ICCPR and other 8 core instrument on human rights is an international treaty that is binding on those countries that ratify it. But is it true that it's only guarantee the freedom of movement is restricted only to those individuals lawfully present in the country? So what happened to them who attend the country unlawfully? International human rights law provides an important protection framework applying equally to all migrants. In general, it's equally to all human beings and protects all their rights, including the civil, political, economic, social, cultural rights, and a number of other universally binding non-derogable norms, such as the principle of non-refoulement. The rights are confirmed also as well under the supplement protocol of the United Nations Conventions on Trans Organized Crime, which also known as Palermo Protocol, both on the trafficking in person and people smuggling. Furthermore, there are 2 global compacts that for refugees and for safe, orderly, and regular migrations. And what is actually different arranged by this global compact? In general, refugees and migrants are entitled to the same universal human rights and fundamental freedoms, which must be respected, protected, fulfilled at all times. However, migrants and refugees are distinct groups governed by separate legal frameworks. Only refugees are entitled to the specific international protection as defined by the International Refugee Law. The Global Compact on safe, orderly, and regular migration refers to migrants in general and presents a cooperative framework addressing migration in all its elements. In addition, the 2030 Agenda for Sustainable Development recognized for the first time the contribution of migration to sustainable development. It can be seen that 11 out of 17 Sustainable Development Goals, or also known as SDGs, contain targets and indicators relevant to migration or mobility. The agenda's core principle is to leave no one behind, not even migrants. The SDG's central reference to migration is made in Target 10.7, stated that one of the goals is to facilitate orderly, safe, regular, and responsible migrations and mobility of people, including through the implementations of planned and well-managed migration policies. Other targets directly related to migrations mentioned such as trafficking, remittance, international student mobility, and more. Moreover, migrations is indirectly relevant to many more cross-cutting subjects. So, who is a migrant? At the international level, there is no universally accepted definition for migrant. The present definition was developed by IOM for its own purpose, and it is not meant to imply or create any new legal category. IOM, through their glossary on migration, defined that a migrant is any person who is moving or has moved across an international border or within a state but away from his or habitual place of residence, regardless of the person's legal status, whether the movement is voluntary or involuntary, what the causes for the movements are, and what the length of the stay is. So, are all migrants vulnerable? Well, while migration is a positive and empowering experience for many, it is increasingly clear that a lack of human rights-based migration governance at the global, regional, and national level is leading to the routine violations of migrants' rights during in transit at the international border or even in the countries they migrate to. While migrants are not inherently vulnerable, they can be vulnerable to human rights violations, especially those in irregular situations. They tend to be disproportionately vulnerable to discrimination, exploitation, and marginalizations. They often living and working in the shadows, afraid to make complaint and denied their human rights and fundamental freedoms. So why people migrate? What are the main factors that drive migration? There are a lot of types of migration, which also can be classified by the cause of the types of these migrations. For example, urbanizations. It can be when someone or an individual wants to look for a better opportunity in the more urbanized area instead of staying in their or maybe in the more rural area. Also, there is environmental migrations, which can caused by the natural disaster, forced migration or displacement, which can also caused by the natural disaster or armed conflict or political repressions in a state that force them to move to another locations for safety. However, there are also positive types of migration. For example, family reunification, international students studying abroad, and labor migrations, which also become one of the most trending type of migrations in the whole world. It can be a challenge to make sense of available migration data, as this is often scattered across different organizations and agencies and not easily comparable. However, IOM's Global Migration Data Analysis Center runs a platform named Global Migration Data Portal, which serves as a unique access point to timely, comprehensive migration statistics and reliable information about migration data globally. From the illustrations of the diagram, it could be seen that in 2019, the number of international migrants worldwide, or people residing in a country other than their country of birth, reached 272 million. Female migrants constitute 48% of almost half of the number of this international migrant stock. On the other hand, 3 out of 4 international migrants are of working age, meaning they are between 20 years old and 64 years old, and 164 million out of these 272 million migrants are identified as migrant workers. So what is the state obligation on tackling human rights violations during the migration process? Responding to the protection needs of migrants under the international human rights law, states have a legal obligation to respond to the protection needs of migrants, including a particular duty of care to migrants in vulnerable situations. These obligations can be fulfilled through a comprehensive, practical, and human rights-based approach to migration governance that should include identification and assessment of protection needs, mechanism for entry and stay based on human rights protection grounds, mechanism for entry and stay based on discretionary grounds, and regularizations and alternative pathways to return. So what happened when state failed to meet its obligation to secure the migration process? And why is it important to have an effective migration governance in place? For sure, there will be potential human rights violations against migrants that can include a denial of civil and political rights, such as arbitrary detention, torture, or a lack of due process. On the other hand, the economic, social, and cultural rights can also be violated, such as the right to health access, proper housing, and education. The denial of migrants' rights is often closely linked to discriminatory laws and to deep-seated attitudes of prejudice or xenophobia. At the heart of the dilemma of recognition of migrants' human rights is their vulnerability to exploitation. As, as observers in Asia has often noted that migrant workers usually fill the 3D jobs, which stands for dirty, dangerous, and difficult. Migrants, especially those who are in irregular or unauthorized status, given their lack of legal recognitions or precarious status in the host countries, can be considered an ideal reserve of very flexible labor. Those without authorization for entry and or employment are at the margin of protection by labor workplace safety, health, minimum wage, and other standards. They often are employed in sectors where such standards are non-existent, non-applicable, or simply not respected or enforced. On the other hand, smuggling migrants and victims of trafficking are more vulnerable to human rights violation because of the particular situations they are in. They may be subjected to serious abuse and exploitations by the smugglers or the traffickers who control the situation. They also usually in an irregular situations where they are afraid to approach the local authority for protection because of being feared of deportation. Yet they are entitled to all the rights and freedoms set in human rights instruments. Trafficking in person is recognized as one of the serious crimes that constitute a grave violations of human rights, and the victim, they should benefit a special protection measures. Furthermore, migrants who are smuggled to cross border are not considered as victims per se. Nevertheless, thousands of migrants died each year from smuggling activities. They are also particularly vulnerable to the other crimes such as kidnapping for extortion, rape, and also the discriminations and ill treatment, including from state or non-state actors. Smuggled migrants itself are often considered as an offender and denied protections of their rights, assistance, and access to justice when they are victims of aggravated smuggling. Here is the common mistaken perceptions that usually take by states. For example, the government, when they think that their migration governance is in problem due to the high number of forced labor victim cases or victim of trafficking abroad, they apply measures such as moratorium on sending migrant workers abroad with the hope that there will be no more victims. Little did they know that besides the act is violates human rights of its people, since state cannot forbid their people to migrate, it is actually put higher risk of for their people and not effective to overcome the real problem. As long as there are no social security mechanism take place, people will still demand to have a job. They want to have their own income. They want a chance to have a better life. Thus, since the government applied moratorium to send migrant workers through the regular channel, it becomes easier for some parties to take advantage by lure the inadequate informed person on safe migration procedure, for example, and trap them into the trafficking in person chain. In fact, the number of irregular migrations will be higher and uncontrolled. Here's an illustration from the IOM Indonesia Counter Trafficking Unit statistic. Since 2005, the first time the unit established in Indonesia mission, there are 9,258 victims assisted, and the majority of the victims are female adults. On the other side of the slide, it explains the significantly different numbers on the category of movements that happen during trafficking cases, which cross-border trafficking it become the majority. So it is important to foster international cooperations among all relevant actors on migration, acknowledging that no state can address migration alone and upholds the sovereignty of their states and, on the other hand, their obligations under international law. Here is the Global Compact for Safe, Orderly, and Regular Migrations. Although it is non-legally binding cooperative frameworks, it recognizes that no state can address migration on its own due to the inherently transnational nature on the phenomenon. It requires international, regional, and bilateral cooperations and dialogue. Its authority rests on its consensual nature, credibility, collective ownership, joint implementation, follow-up, and review. Inside this Global Compact for Migration, there are 11 guiding principles, 23 objectives, and a lot of commitment for safe, orderly, and regular migration. And trust me when I say a lot, because it is a lot of commitment for from a framework, from a non-binding framework per se. So the interesting about this global compact, this compact recognized that safe, orderly, and regular migrations works for all when it takes place in a well-informed, planned, and consensual manner. Migration should never be an act of desperation. However, when it is, a response to the needs of migrants in situation of vulnerability is needed to address the respective challenge by commitment to facilitate and ensure safe, orderly, and regular migrations is benefit for all. The Global Compact is also adopted the international human rights law approach and upholds the principles of non-regression and non-discrimination. By implementing the Global Compact, states will ensure effective respect, protection, and fulfillment of the human rights of all migrants, regardless their migration status. So whether they are lawfully or unlawfully enter a state, they can be protected by this framework across all stages of migration cycle. So whether during the transit at international borders or in the destination country they migrate to. States will also need to reaffirm the commitment to eliminate all forms of discrimination, including racism, xenophobia, and intolerance against migrants and their family. For sure, for the effective implementations of Global Compact, it will require quite a lot of efforts at the global, regional, national, and even local levels, including a coherent system of the United Nations. However, although it is still a long way and requires endless efforts, the limitations on the existence of migration policy or governance in national, regional, and international level should never justify the human rights violation towards migrants. And to sum up, allow me to quote a famous saying by Ban Ki-moon. He said that migration is an expression of the human aspiration for dignity, safety, and a better future. It is part of the social fabric, part of our very makeup as a human family. So that is all from me. Thank you so much once again for all the committee for giving me the opportunity to present a brief recap on human rights and migrations. For further questions and discussion or even future collaboration, if it cannot be accommodated through this forum, kindly reach me through my email. I stated both email, my working and my personal email. Once again, thank you.
Thank you very much, Miss Hana Saima. It is very proud of us to have you back as one of our alumni in this event. So we are looking forward also for further collaboration in the future. So thank you for the presentation about the topic human rights and migration. And yang bisa saya simpulkan adalah migrants are protected under the international human rights law framework, applying equally and must be respected, protected, and fulfilled at all times. And of course, states have a legal obligation under international human rights law to respond to the protection needs of migrants, especially migrants in vulnerable situations, by creating a necessary and effective migration governance and policy. However, no state can address migration on its own. Therefore, international cooperation is needed to ensuring that safe, orderly, and regular migration for the benefit of all is reached. And now we will move to our third and the last speaker, who is Professor Maria Teresa Gilbaso. Welcome, Professor. And before Professor Maria start, I will give a brief explanation. Professor Maria Teresa Gilbaso is tenured professor of international law at University of Navarra, Spain. She is also a research associate at the African Center for Migration and Asylum at Wits University, South Africa. And she is an external expert at the AU Asylum Office in Malta. She qualified as a lawyer in 1993 and also a member of the Spanish Bar Council. Professor Gilbaso regularly provides expert advice to international organizations, notably the UN and the AU. Professor Gilbaso has already published extensively in the field of asylum and human rights, and several of her publications are among the most read and cited, selected by Oxford University Press for its collection of selected materials on international refugee law. So today, Professor Maria Teresa Gilbaso will deliver the topic presentation about business and human rights, the historical background and future directions on the movement of people. So Professor Maria Teresa, the time is yours. Thank you.
Hello, can you hear me now? Can you
Yes.
hear me?
Yes.
Okay, good, thank you. So thank you very much. I would like to thank, first of all, the organizer, Patricia Audrey, for her invitation, but also for the ongoing communication that we have had over the years. It is always a pleasure for me to participate at an event of the University of Brawijaya in Malang that I think of with affection since the last time I was there 3 years ago now. So it is a pleasure for me to join you all today. I've been invited to speak about human rights, business and human rights. So I'm going to share the screen with you for the PowerPoint presentation. So that should be working now. So I wanted to speak a little bit about the background between human rights and business from a historical perspective. How do we talk about business and human rights? How did it come to happen? So what are the links and the connections between these two areas of law? So I wanted to present the state of play at the moment, to look a little bit back in historical context, then discuss a case study, and then move on to consider future directions. The first thing I'd like to say is that we always speak about the relationship between businesses and individuals and human beings historically in a context of trade and commercial relations. Nowadays, we're very used to speaking about the movement of capital, the movement of goods, the movement of services. We know that we can manufacture products in one country that are then sold and shipped over to be retailed in another country. The same happens in relation to capitals and services. We are using Zoom, which is a number of people across the world at the moment in different countries, and we are using a service provided by a company which is not based in many of our own countries. So where does this relationship between individuals and human beings come from? So that's what I would like to talk about. When it comes to the state of play at the moment, and I think it's helpful to start there, it's important to see that the pressure that has been put on governments and on countries across the world to come up with some sort of framework for the communication and identification of these resources was only recently established. We have a resolution of the UN Commission on Human Rights of 2005. So that's only 15 years ago, which is not a very long time ago, that decided to appoint a special representative of the UN Secretary General with a mandate to identify and clarify the standards of corporate responsibility and accountability for corporations that operate in a transnational context and other business enterprises with regard to human rights. So here the important point is that the connection that we're talking about is not about business and human rights in relation to the countries where the companies are based, but in relation to the investments and operations and services that they provide abroad. So this human rights connection is always in relation to foreign individuals in foreign countries. And that's, I think, quite important to note. So why are we focusing on foreign countries and we're not focusing on our own countries? Well, there is a reason for that. So that was the first step in the process. In 2008, the United Nations adopted a framework which is called Protect, Respect, and Remedy. And there is a very strong link there to prevention, to the fulfillment of human rights obligations, but also of the principle of reparation, a long-standing principle of international law that allows us to determine when a wrong has been committed or an injury has been committed and how you make the wrong right. And that would be the principle of reparation in international law. And that framework was adopted in 2008. Finally, in 2011, the United Nations adopted the guiding principles on business and human rights, which were unanimously endorsed by the Human Rights Council. So that's about 9 years ago. so not very long ago, that we do have these guiding principles. So first we have a mandate of the UN Secretary General to appoint a special representative to look at those standards, identify and clarify the standards. So that's the state of play. Where are we now? Then we move on to develop a framework in 2008, and then we come up with these guiding principles in 2011. So what's the operational structure to develop all that? The fact that we have guiding principles is already telling us that we do not have an international treaty, and therefore we do not have legally binding standards. What we do have at the moment is a working group on business and human rights. And that working group, has identified special procedures that are going to be following those connections and work between foreign companies acting in foreign countries. This working group is made of 5 independent experts, and their role is fundamentally to conduct and monitor and develop the businesses of the annual Forum on Business and Human Rights, which is an annual gathering of everyone working in this area once a year in Geneva to discuss the focus and implementation of these principles. But perhaps most importantly, it has a mandate to work towards an international legally binding instrument. So the development of legally binding standards to regulate the activities of those transnational corporations. This is quite important because we do know that very often the movement towards protection starts like this, with UN General Assembly resolutions or resolutions of non-legally binding nature adopted in the United Nations, which are then moved forward towards an international agreement of legally binding nature. If we do not have a treaty, we do not have standards to hold the states accountable for. But it is part of the rationale of international law to allow states to work and cooperate together, first of all, in a non-legally binding manner. And that is what the guiding principles aimed at providing for. So you do create a set of standards that allows practice to become more homogeneous among states, and you create a forum for all states and businesses to exchange together once a year, and eventually the goal is to reach that legally binding instrument, an international treaty to regulate those activities of corporations acting in a transnational context. Of course, we do know that there are very strong interest on the part of states and also a very strong interest on the part of companies, and that it is not always the case that there is a political will that might allow for those standards to be turned and developed into legally binding ones. But that is what the work is going to at the moment. So what do these guiding principles tell us? We can, of course, go through them at length, but I think it's important just to remind ourselves of the 2 fundamental principles that they set up. First of all, that the primary role of human rights protection is within the states. So this is not with companies. It is the states who must protect the human rights of everyone in their territory or under the jurisdiction, including human rights violations committed by third parties, and that includes business enterprises. So we live in a world or in an international legal order which is state-centric, and international law will always go back to the state. So it is a state who is sovereign, and it is the state who has both the duty and the right to protect their own population against human rights abuses, including those committed by foreign companies. So it is the duty of the states to take appropriate steps to prevent those abuses from happening in the first place, to investigate if there are allegations, and to punish and redress, again, the principle of reparation, those abuses by means of effective policies, legislation, regulations, and judicial remedies. So the onus falls on the state that allows transnational companies to operate in their territory to ensure that the activity of those corporations is regulated. So we're talking about issues of labor, we're talking about issues of protection in the workplace, we're talking about issues in relation to deforestation or pollution of waters and other natural resources. We're talking about standards all through the process of manufacturing, production and export of goods. So that's on the part of the state. And the other side of the coin in this framework is that business enterprises, so transnational corporations, should respect human rights. If you look at the language, you see a legal obligation on the states must, so that's mandatory language, but we only see a recommendation when it comes to businesses. Businesses should respect. There is not a mandatory language, and that is, I think, quite telling about where we stand. It is true that an international non-legally binding instrument cannot impose obligations, and what it is doing here is reminding states of the obligations that they already have as sovereign states, but perhaps it could have gone a bit farther in ensuring that there is already a commitment or an expectation that businesses will commit, as opposed to a mere recommendation businesses should respect. When we talk about the human rights that need to be respected, we're talking about the United Nations Bill of Rights, and that is the UN Declaration of Human Rights, and the two legally binding treaties that were developed after that. The UN Covenant on Civil and Political Rights of 1966, and the UN Covenant on Economic, Social and Cultural Rights of the same year, both of which entered into force in 1976. So that is the framework. So we're talking about the International Bill of Rights, and we're talking about a duty of the state to protect and to take actions. So that is positive obligations on the part of the state. But when it comes to businesses, we're only talking about a recommendation to respect those human rights. So what is the historical background to this? Why are we talking as of 2005 and a bit later of this corporate responsibility? There is a trend to try and assume that everything that we are doing today in our own time under the United Nations is something new. But when we look a little bit back in history, we see that that is not always necessarily the case. In fact, when it comes to the relationship between individuals and businesses, between states, individual states and businesses, we do have a very rich historical background. So we already do have a connection of the early international protection in context of a trade and human mobility. So I think probably many of us are familiar with the Silk Route and the Middle Ages routes that connected the Far East, what Europeans call the Far East, with Europe, and that is China, India, Japan, Indonesia, and other countries where Europeans went to look and trade for silk, for spices. And this was done under proper international agreements whereby the receiving countries at both ends, and there was a monopoly by the Republic of Venice at the time, committed to each other to respect and protect the merchants and their businesses and their premises. So international trade and commerce was already a source of wealth for governments and for states across the world, for sovereign monarchs, mostly at the time. So businesses had to pay taxes, and there was an interest in keeping that very rich commercial and trade route alive. So this capitulations regime, which is a collection of treaties whereby the sovereigns of both countries, on the part of the Europeans, it was truly a monopoly on the part of the Republic of Venice, and later on by the Republic of Genoa, that led to this adoption of agreements with China, Japan, India, and so on, for the protection of their merchants. So it was very interesting for those sovereigns to ensure that there was protection of the routes and of the merchandise all along the way. So this is a background that is talking about the protection of the businesses and not the protection of individuals in relation to the activities of the businesses. Okay, so we start with an international regime that is seeking to protect the merchants and their businesses against foreign action, but also against any kind of harm or damage or injury that might be committed against them by the local population or by other businesses. And this is what led to the institution of diplomatic protection, which is one of the most ancient institutions in international law. And one of the most ancient areas as well of international state responsibility has to do with those responsibilities for injury to aliens. So what is this system that we're talking about? We're talking about a situation whereby when an individual, a merchant, but it could be any individual, but in practice it was about merchants, it was about individuals engaged in trade and commerce, so the actual transnational corporations of the time, suffered damage or injury, for instance, a destruction of property, the premises, the merchandise, or an unfair treatment at the hand of the foreign state. Usually this took the form of confiscation of property and of expulsion without any due cause, and most importantly, without paying the market price. Then the country of origin where the business was established could issue a claim against the foreign state for that injury to aliens. So the understanding in international law at the time was that any injury committed against foreign merchants was an injury committed against the state of origin of the merchants themselves. And we have more than 1,000 years of this legally binding framework that protected businesses against foreign action, businesses operating abroad. So we have moved now from that very long-standing, historical long-standing tradition of the protection of transnational businesses to a realization more recently that in the era of human rights, the local population must also be protected against the abuses that those transnational businesses might be able to commit when we are in the presence of a transnational activity. I have said before that at the beginning of this presentation that the United Nations is working towards the development of a legally binding instrument. So what would that legally binding instrument look like? I thought it would be interesting to have a look at a case study because the European Union already has this kind of agreements with countries across the world. In the context of the European Union, and that was due to the pressure by human rights advocacy organizations, there was a pressure put on the European Union to ensure that any kind of connection, any kind of treaties that it adopted with foreign countries for trade and commercial purposes ensure the inclusion of a so-called human rights clause. And that clause specifically states that there is a legal obligation for both parties, so for the European Union and its member states, as well as for the countries abroad with whom the European Union is doing businesses, to protect human rights. But the question is, how far do these human rights clauses go? What happens if there are human rights violations? Do they make the treaty null and void? Do they engage the international responsibility of the state? Well, in practice, it is not always so clear. Interestingly as well, we see in some of those association agreements, I think the most developed example of it is the one with Turkey. There is often a chapter in relation to free movement of workers. So there is a connection between not just the trade and commercial activities of businesses, but also the acknowledgement that businesses are actually run by individuals. And therefore there needs to be some form of human movement or free movement when it comes to very certain specific categories of individuals. And interestingly, when it comes to the European Union, there is that right of diplomatic protection that I was talking about as an instrument of international law that has been developed in the context of the Charter of Fundamental Rights. So it has become a fundamental right, the right to be diplomatically protected when operating or finding yourselves abroad. The European Union has a number of association agreements with countries across the world, and these are also countries in the Asian region. Negotiations have been completed with Singapore and Vietnam. So already in 2014 with Singapore and in 2015 with Vietnam, that will eventually lead to these bilateral trade agreements. And negotiations with Indonesia started in 2016 and are still ongoing. These bilateral free trade agreements, the idea is that they will lead eventually towards cooperation region to region by means of a full Asian agreement with the European Union, whereby both parties commit themselves to operate and develop these trade relationships, and that will have to include, as a matter of legal requirement, a human rights clause. That human rights clause will have to do with the way workers are treated, with the standards in which production of goods and services is developed, and the violation of those human rights we see in the context of the European Union has had a variety of consequences, but the general agreement is that there is a criticism that eventually it does not lead to the suspension of a treaty, but it only might lead eventually to sanctions or to different restrictions in the way that trade and commerce operates. So if this is where we are now, this is where we're coming from historically, and we've seen that move from the protection of the businesses themselves to a protection of the human rights of the individuals in the country where businesses operate, now in the UN era. And we see what kind of agreements we could eventually develop if we have a look at the existing agreements that do include a human rights clause between different countries across the world. Then what are the future directions? Well, I think we are all aware the fact that we are all here connected in this virtual way. It's a testimony to the interconnectedness of the world that we live in. And that also means the interconnectedness of global markets. With this interconnection and increasing activity across global markets, there is a need to ensure the security in commercial transactions. So if we're thinking or expecting companies to invest anywhere in our own countries, we need to ensure that those commercial transactions are protected. But there is also a need through that increasing activity of foreign businesses in foreign countries, and need to ensure that there is a true enforcement of international human rights law. So in other words, there cannot be a situation where we are moving away from national context, where situations would be dealt with nationally, so that means locally, to a situation where we have foreign corporations acting anywhere. And the fact that they are based in a foreign country should not lead to the impunity for their actions in a way which would be different if they were based in the country where they actually operate. And with this, I would like to leave it here so that we can pass to the discussion time. Thank you very much.
Thank you, Professor Teresa, for the wonderful presentation. So I will give a brief summary now in bahasa. Jadi dalam presentasi ini, Profesor Maria Teresa membahas tentang bagaimana relasi antara bisnis dan hak asasi manusia, dan bagaimana seharusnya negara juga punya peranan dalam memberikan perlindungan kepada warga negaranya untuk mencegah terjadinya pelanggaran hak asasi manusia. termasuk juga dalam pelaksanaan bisnis harus mengedepankan nilai-nilai yang tidak men-violate proteksi terhadap human rights. That's all of the presentation for all of our keynote speakers. Thank you. Thank you very much for the presentation, wonderful presentation. Now we came to the question and answer session, and there are actually a lot of questions. I think I will go for the first 3 questions. The first one is from Ibu Ikaning Tias for Miss Ayu Hana, which is from Ibu Milda, what is actually the main obstacle faced by Indonesia in preventing people smuggling? And second is also for Ibu Ayu Hana from Ibu Ikaning Tias. Since Indonesia has not ratified the International Convention on Refugee 1951 and also the protocol, but in fact, Indonesia has already become the transit state of migrants and refugees. So is it urgent for Indonesia to ratify the convention? And the third question for Dr. Iman and Professor Maria Teresa is the question is, how about the opinion that the fulfillment of human rights is always inconsistent with the spirit of investment, since state often makes concession on corporations to meet human rights standards because they want to facilitate investment. I think maybe Miss Ayu Hana can answer the question first.
Okay, thank you, Bu Audrey. I would like to answer the first questions from Bu Ika about the 1951 conventions on refugees and why Indonesia is not ratified the convention yet. Well, for sure, it's due to the political interest of our state, because when Indonesia finally ratified it, it means that there are a lot of more obligations that needed to be done when the migrants or the refugees, after the UNHCR granted their status, while they are waiting in Indonesia. For the case for now is that a lot of migrants transit in Indonesia during their way to go to the third country, such as Australia. And if Indonesia become the state parties of the convention, it means that the government need to do a lot of work from the budgeting until providing the fulfillment of the human rights protections. And it become the state obligation, the state duty, the state responsibilities. And I think to date, that is the one thing that actually become the main considerations for our government to not ratify the convention. And of course, the political interest also shows that actually, even though the government did not ratify the conventions, we are trying to advocate the government by the regular standard of the human rights recognitions for all people. However, it is also quite hard to make the government willing to give more than what it takes for the refugees during their transit here. For example, the right of education. A lot of unaccompanied migrants and refugees stay in Indonesia for more than 5 years, and they did not get the proper education, for example. However, the international organizations such as IOM and UNHCR tried our best to advocating their rights and making it is possible for them to have or to still receive the educations. And it is proven that in some locations such as Medan and Makassar, where there are our accommodations for migrants or refugees that registered to the UNHCR and under IOM care, they can go to the to some local schools and get their rights of educations there. However, it is not like applied in all the regions where migration stays under IOM care. So if the question is it urgent? Yes, it is urgent. However, it will come back to the political interest of a state, especially Indonesia, in this thing, whether they want to make the issue is priorities or not. And for the second questions, I think it's from Bu Milda. So what is actually the main obstacle faced by Indonesia in preventing people smuggling? First of all is the lack of legal comprehensive legal understanding from the people living in the vulnerable area. For example, they are living next to the sea, or the potential smuggler, to understand about the concept of people smuggling. As far as they know, when the migrants ask for their help to cross the sea, for example, to go to Malaysia border or uh, to go to Australia and Indonesia border, they just know that, oh, they want to go there. They have no adequate knowledge that, oh, for you to go and cross the border between Indonesia and Malaysia, for example, you need to have a proper passport. If you want to working, then you need to have a proper visa. They really have no educations to understand about that. And that is why it is also important for the government to reach until the outer border of Indonesia and educate or raise awareness to these people that it is actually important to for them to understand the concept of people smuggling. However, if we take a look at the concept in Indonesia, they barely even know their basic rights. So I think it's also become the burden, because like how will we can make them understand about the concept of people smuggling if maybe they don't even know what human rights is. So that is actually the main obstacle faced by the government of Indonesia in preventing people smuggling. However, there are a lot of organizations such as IOM and local NGO who already try to tackle these issues in some vulnerable areas. And hopefully in the future, the work can continue and getting wider, and it can help the government of Indonesia to tackling such issue. Because in 2020, actually, or no, since 2018, since Australia closed the border strictly, and they even cut the budget for to help the refugees at that time until now, it's the number of smuggling cases that cross Indonesia, it's actually lower if we compare it with like 5 years ago. So I think the work that the government doing and a lot of other stakeholders doing, it actually works. And hopefully there are no more cases of people smuggling, since the new Ministry of Marine Affairs and Fisheries will welcome foreign fishing vessel to enter Indonesia. And I think it's also will become quite a challenge when the foreign fishing vessels entering the Indonesian water, because it could be also one of the way for the migrants to be trapped in the smuggling situations, or people take fortune from the situation to smuggle migrants. Thank you.
Is there any feedback from Bu Tias and Bu Milda? Okay, I think it's enough. Sorry.
We couldn't hear you, Audrey.
Yeah. Okay. So sorry for the inconvenience. The second question goes to Professor Maria, which is the question is related to the fulfillment of since the opinion on the fulfillment of human rights is always inconsistent with the spirit of investment, because sometimes the state often makes concession on cooperation to meet human rights standard. Is it true, or what can we do? Thank you.
Thank you for the question. I completely agree that this is the criticism that has been mostly expressed, that there is a tension almost impossible to resolve between the desire of the states to allow for transnational investment and that protection of human rights, that in fact concessions are made in order to facilitate that transnational activity in foreign countries. So from a perspective of action enforcement and where we are at the moment, it is not very satisfactory. But that is precisely where these initiatives find grounding. So the fact that we have moved from nothing in terms of the human rights protection of the local population where companies actually operate, to a situation where there is at least an understanding that there has to be some form of facilitation and an acknowledgement of responsibility, that's already quite a step forward. The fact that there is a human rights clause that will apply to any kind of commercial trade agreement between any country in the world and any European country, then also is telling us that there is at least an acknowledgement that it should be there. There are deficiencies in the implementation and it's far from satisfactory, that is indeed for sure, but that is what we are trying. I think that's what the law is at the moment, or the policy is at the moment, trying to achieve, that sort of moving forward to an acknowledgement and recognition that it shouldn't be the case. So we are still at the infancy of this development, but the fact that we have a situation where for centuries, for more than 1,000 years, it is companies who have been protected, to one in which we're starting to move slowly away from the protection of companies to the protection of people and the human rights of people, then I think that's a step in the right direction. Yeah.
Thank you, Professor Maria Teresa. And there's actually one more question, because we have a tight time. So the question also goes for Professor Maria Teresa from Mr. Hadi Purwadi from UNS. And it is about the national legal regime. And even though at the international level, an agreement concerning business enterprise to respect human rights that legally binding, and the country have a right to ratify them, but the agreement in Indonesia is not directly have binding rules, since there is a long process to realize in the Indonesian political context. So is there any comparison related with this issue? Thank you.
Okay, so this is a question again about enforcement and a very practical perspective. We might have an international treaty, but there is little use for it if we cannot bring it into the context of the action enforcement. Okay, so I was saying that we might have an international treaty, but it might be very difficult or impossible to fulfill if we are in a situation where the agreement has not been brought or incorporated into national legislation. There is a rule of international law whereby states cannot argue issues of domestic legislation in order to justify the lack of fulfillment with international treaties. So when this situation arises, and this is common to a number of countries, the majority of countries in fact require for an international treaty to be applicable at domestic level, that it will have been brought forward in that context. So we are in a situation where the whichever country that is, might have to comply with the law regardless of whether it has been enforced nationally or not. In Europe, we have seen this in the context of the United Kingdom, who became a party to the European Convention on Human Rights in 1950, but it took almost 50 years till 1998 to bring it forward as an act of parliament, as a domestic act of parliament. So in that situation, what we saw were a lot of cases going through courts and a lot of cases going to the European Court of Human Rights, precisely because of that violation of international law, which was allowed by the domestic legal order. So what can happen in Indonesia? If there is a disparity in a way in which international legally binding standards are applied at domestic level, then there will need to be a move towards using whichever domestic arrangements are enforced and available to challenge the constitutionality of the situation. Human rights are usually protected by means of constitutional provisions, and that gives them the highest rank of protection. I do know that the Indonesian constitution is a very strong instrument, and it does take account of those safeguards. So that might be the way to go forward if eventually there is a disparity in the way in which human rights are being protected in relation to those international agreements by the activity of international business investment. Thank you.
Thank you, for Professor. Is there any feedback from the questioners? Okay, I will move to the next question for Dr. Iman. There are actually three questions. The first one is about what is Dr. Iman's opinion about the fulfillment of human rights is absolutely inconsistent with the spirit of investment, since the state often makes concessions on corporations to meet human rights standards and because they want to facilitate the investment. And then the second questions. The second question is how important health as human rights. If health is one of the human rights, what about the cases of maladministration in pandemic like this? And also the last question for Dr. Iman. It is a question from Ibu Rika and asking from the academician perspective about how effective the cooperation between countries to prevent the spread certain disease. As in fact, we know that our world have faced several pandemics before, and and the World Health Organization, some of them have failed in surveillance system. Thank you very much.
Thank you, Ibu Audrey. I have three questions. One is from Ibu or Mbak Astrid Alicia, Ibu Hikmatul Ula, and Ibu Rika Kurniati. Ibu Astrid, indeed, maladministration or bad governance of administration can lead to violation of human rights. As we know that in the human rights regime, government is the main duty bearer, that is to respect, to protect, and to fulfill. There are two more duties that usually also have to be provided by government, that is to prevent and to promote human rights. In relation to good administration and governance, it is very much related with government's duty to fulfill human rights. So without good administration, it is more likely that the government will fail to fulfill human rights. Yeah. In the case of health, rights to health, or other case which falls under social, economic, and cultural rights, there have been many violation of ERC rights that being brought to the judicial authority, to the courts in Indonesia, which rooted from the failure of government to provide or to act to have good governance. For instance, the rights to water in Jakarta, in the case of Palija Aitra against governor of Jakarta, and in the case of national examination, ujian nasional, those are related with economic, social, and cultural rights that can be brought to court. So yes, bad administration, bad governance, even corruptions, for instance, will lead to violation of human rights, will potentially lead to violation on human rights, and will lead to the failure of government to provide human rights. For Bu Hikmatul Ula, like I mentioned before in my presentation, globalization and privatization are two major issues that might hinder global cooperation on human rights. However, there are a number of efforts at international level to balance the interests of investments and protection of human rights. For instance, there have been ideas to reform the investor states dispute settlement, ISDS, mechanism to include or to consider human rights issues when adjudicating, when the arbitrators adjudicates investment disputes. Also, to allow counterclaim from the states to also include access to water, social justice, and human rights to be considered. So, however, we still face many challenges for international cooperation, particularly because of globalization and privatization. For Ibu Rika, I can say that the current form of international cooperation is very limited and has very and not effective and offer an ineffective way to tackle the disease. Yeah, despite the advancement, the technology that we all have in industrial relation 4.0, normally the disease should have been tackled at the early stage. Yeah, using the technology, the share of information that we have, and other artificial intelligence or many other algorithm and whatever. But as we seen today, the global death caused by the disease increasing day by day. So I can say that the global cooperation in relation to international disease, I think needs to be reformed. Yes, we have experienced other disease before, Ebola, SARS, and other disease, but never before that we face a situation, a pandemic like what we are facing today. And some countries actually deny cooperation. For instance, the US have accusing WHO for being political in coordinating the pandemics. And the response from other states might be also different. So we need more cooperation, international cooperation to tackle this pandemic. I think that's all I can say, Ibu Audrey. Thank you very much.
Thank you, Dr. Iman. Actually, there are still a lot of questions, but unfortunately, we have a bit tight of time. So this is one last question from Professor Hassan Kakaya for all presenters. The question is, do multinationals that engage in monopolizations, unfair trade practices, and violate privacy rights breach human rights? Maybe the presenters can give a brief, all the presenters can give a brief statement, and please give about 1 minute closing statement for today's conference. Thank you very much. Maybe we start from Professor Maria Teresa and follow with Miss Ayu Hana and follow with Dr. Iman. Thank you very much.
Right. So thank you very much for the opportunity to be here with all of you today. In relation to this very last question about whether multinationals might violate privacy rights, privacy issues are very much going into a direction where there is increasing consideration in a context of an online communication. So how companies access our data and how they use it, how it is sold or transmitted is an issue that is increasingly subject to international agreements as well. So this is a way in which there is an increasing movement towards that accountability. But this is done by domestic national authorities. So it is up to each country to determine whether foreign transnational corporations like Google or Zoom or WhatsApp or whatever are actually in breach of this privacy data. So I think that's about my minutes, and just again to say that it's been really good, very, very nice to be with all of you today. Thank you very much for the opportunity.
Yes, thank you, Professor Maria Teresa. And next goes to Miss Ayu Hana.
Okay, thank you, Bu Audrey. Thank you for the questions, Professor Kakaya. I must say that I'm not an expert in private international law because all of my study and research mainly focusing on the public international law. However, in addition to what Professor Maria already stated, I would like to refer to the United Nations Guiding Principles on Business and Human Rights, which if the regulations or if it's not arranged under the contract between states or the customer and the company, for example, actually the corporate under the United Nations Guiding Principles on Business and Human Rights has responsibility to protect human rights, which privacy rights is one of the human rights included in that. Both during the foundational principles of the business or their operational principles. And as my closing remarks, once again, I would like to say thank you to all the committee for letting me present today. And hopefully we can all agree on the concepts that even a state is not yet have a proportional migration governance and policy, it is not a limitations to protect migrants. Thank you.
Thank you, Miss Ayu Hana. And next to Dr. Iman. Silahkan.
Okay. Yes, there's a growing number of business activities today that conducted through internet and online facilities, and it creates a new problem. It's not new actually. It creates a problem of privacy rights privacy is part of human rights, but privacy in relation to internet activities is quite new, and Indonesia now is struggling to find a better way to regulate. We have our undang-undang, our law that is being criticized for lacking of clear rules and regulations whether privacy rights should be protected or not. However, although companies today holds a huge number of our data, we must not also forget that government itself, the government holds all of our personal data, and government also can play significant roles in protecting our privacy rights. Yeah, I think that's all I can say to answer the last question. Thank you, Ibu Patricia, Audrey.
Yes. Okay. Thank you, Pak Dr. Iman. So, ladies and gentlemen, finally we comes to the end part of this conference, and I'd like to thanks very much for all the keynote speakers for the wonderful presentation, and for all the participants to being a very active participate, and hopefully I hope this international conference will benefit for all of us, and we will still strive for the future in the knowledge. So stay safe everyone. Thank you very much, and assalamualaikum warahmatullahi wabarakatuh. So actually, I also want to give a brief announcement to all participants in this international conference. Please write your PS code before your name and institution, since we are going to assign you in the breakout room like PS 9, 10, 11, or 12. Thank you. So thank you. Terima kasih ya, Mbak Ayu, Hana, Saima. Terima kasih banyak Pak Dr. Iman. Nanti kita kapan-kapan kolaps lagi. Dan and thank you very much Teresa, Professor Teresa, for the contribution. And we are from Faculty of Law looking forward for future collaboration with you in many aspects in trade law. Thank you very much, everyone.
Thank you so much.